Hello, I am Reiner Fuellmich and I am one of the founding members of the German Corona Investigative Committee. I'm licensed to practice law both in Germany and in California, and I was there in California from mid-February until the end of May of this year. From there, I watched in amazement how the situation in Germany and Europe unfolded. Initially, that is, up until early March, there had been talk that corona was a comparatively harmless flu virus, which the majority of the population wouldn't even notice. Face masks, like they were used in China, wouldn't help anyway, it was said. But suddenly this assessment was reversed by the very same people who had previously declared everything to be well under control. At the end of March, a lockdown was imposed in Germany, which, I could hardly believe it, in one single stroke suspended all fundamental rights guaranteed by the German constitution. Even less could I believe that, at least initially, far more than 90% of the population had nothing to object to, but instead submitted themselves without asking any questions to the anti-corona measures, and that all of the mainstream media had fallen into this official line. As a lawyer, one knows, of course, that there are two sides to every coin, and that there's always more than just one single opinion on anything and everything. Actually, non-lawyers know that too. That is why I started to look for other opinions than just those of Professor Drosten, who had been Germany's official virologist until then, even though he had changed his views from basically harmless to extremely dangerous. First, I found statements from my friend Dr. Wolfgang Wodak published on the internet by alternative media outlets, and I called him. He referred me to other people and their opinions, in particular that of the highly respected health scientist and statistician and professor of medicine and epidemiology, Professor John Ioannidis of Stanford University in California. But he also drew my attention to the equally highly respected German professors of medicine and epidemiology, Bakti, Mölling, Streeck, the financial scientist Professor Homburg, and the forensic scientist Professor Püschel, and their statements, which are all available on the internet. All of them, in my view, convincingly on the basis of their many years of professional experience and their own studies, still maintained the initial view as it was originally held also by Professor Drosten, according to which, firstly, the coronavirus had existed for a long time, and secondly, that it was no more or less dangerous than the seasonal flu virus. Professor Homburg even proved that the lockdown could not have had any effect in Germany because it was announced 14 days after the infection rates had already begun to drop again, just like the seasonal flu. I was not only astonished but deeply disturbed to see that these other opinions were not only not heard, but that any discussion of them was avoided by first dismissing the other opinions as conspiracy theories and then denouncing their authors as, for example, COVIDiots. Then someone leaked the so-called panic paper of the German Federal Ministry of the Interior, which explicitly called for intentionally causing the population to panic. I was downright shocked by the explicit message therein that children should be made to feel responsible for the possibly painful, tortured death of their parents if they did not comply with the measures. This reminded me more of our dark German past than of a democracy with inalienable basic rights as guaranteed in our constitution. Afterwards, an official of the Ministry of the Interior leaked the so-called false alarm paper, which explained in great detail that the so-called corona pandemic was, in fact, a false alarm, and that the consequences of the measures ordered by the federal and state governments would cause far greater damage to both public health and the economy than the coronavirus itself could ever have done. At first I wondered why no lawyer came forward on this subject. After all the constitutionally guaranteed fundamental rights that are vital to our democracy had been suspended indefinitely. Therefore, in mid-April, I made a video on my YouTube channel entitled, "When Will the Lawyers Come Out of Hiding?" In a second video, I reminded people of the ancient Roman legal principle, audiatur et altera pars, listen to the other side as well. And when I then saw how people were forced to die completely isolated at the end of their lives, alone and without their loved ones being able to be with them, how suicide rates skyrocketed, how millions of medical operations, necessary, not elective surgery, were postponed, and how unemployment rates exploded, I made 2 videos about this too, and pointed out that in my view, these consequences of the corona measures were in fact a really good reason to panic. I could not believe that all this was ultimately based on one single opinion, which was possibly wrong, and that apparently no one wanted to take note of any of the other opinions. My personal legal hero is the Supreme Court Justice Louis Brandeis, the famous people's lawyer, who at the beginning of the last century successfully reined in powerful but fraudulent corporations, especially the financial corporations. Justice Brandeis had determined about 100 years ago, powerful financial firms will stop at nothing, let alone fraud. However, in order to be able to see this, it is necessary to take a close look at all the facts, and in particular, shine a bright light into the shady areas in order to establish the true facts. Sunlight is the best disinfectant, is one of his best-known quotes. At the end of May, I made this the title of my last video before we returned to Germany. And that is exactly what our Corona Investigative Committee is all about. First, to finally let those other opinions become public knowledge, and second, to illuminate the many dark, confusing, and fear-inducing corners of this so-called pandemic. Everyone should be able to form their own informed opinion as to whether these anti-corona measures, especially of course the lockdown and the face masks, have both a factual and a legal basis, or whether in the end, as more and more people seem to fear, that the virus is not any more dangerous than the seasonal flu, the tests are unreliable, and a review of the measures after 14 days or at least 3 weeks would have shown that they were neither necessary nor appropriate. We also want to know who is profiting in which way from those anti-corona measures. Should it turn out that the lockdown and other measures were without a sufficient factual and/or legal basis, this will have both legal and political consequences. And then one of the political and legal consequences will have to be the payment of full and complete compensation for damages suffered, especially to small and medium-sized enterprises, artists, and the self-employed who, unlike corporations, which have been paid billions of euros in compensation on demand, have so far received either little or no compensation at all. In any case, not at all adequate compensation. The longer the restrictions continue, the higher such claims for damages will pile up until September of this year, by which point in time, according to many banks' estimates, the full extent of the economic catastrophe caused by the anti-corona measures will become visible for everyone. Why are we doing this as lawyers? Because it is the original task of lawyers to find the facts and then evaluate them from a legal perspective. However, to do this, we need the expertise and professional competence of the scientists and medical practitioners mentioned above. Therefore, we will listen to them and question them. As a trial lawyer, I personally have 26 years of intensive experience with structurally superior, that is economically and or politically very powerful tortfeasors such as Deutsche Bank. That is why we feel that we are very well equipped for what the Corona Investigative Committee is now doing, hearing expert witnesses to put together the facts of this crisis.